Welcome back to the Watchdogs Family Protection Services. We're here to shine a light on family court injustices and systems that claim to protect children but often fall short. I'm your host, and today we're diving into a powerful decision out of West Virginia Supreme Court, case number 23611. This case decided on May 30th, 2025, involved a mother who had her parental rights terminated in Canal County Circuit Court. A case presided over by Judge McInclear Akers. The Supreme Court, in a rare but critical move, affirmed termination but vacated the denial of post-termination visitation. That's right. They said no to the lower court's refusal to even consider whether the children wanted to maintain contact with their mom. Let's break it down. The mother, A.L., had a history with CPS and the Department of Human Services going back to 2018. There were serious incidences, including the separate gun-related accidents involving the children, all due to lack of supervision and dangerous living conditions. She didn't complete her services, she didn't follow through with her case plan, and so the court terminated her parental rights. The Supreme Court upheld that part. They said, yes, the facts show the parent didn't fix the situation, but, and this is where the matter for all of us, the court said something we rarely hear in these cases. They said post-termination visitation is not about the parents. It's about the child. Let me say that again. The child has the right to maintain a bond with the parents if it is in their best interest. This ruling cited cases like in R.E. Christina L. and Billy Joe M., showing that emotional bonds and wishes of older children must be considered, not ignored. The bottom line, the Circuit Court ordered a remand. That means the lower court has to go back to the actual evaluate based on the child's wishes and maturity, whether that post-termination contact should continue. Here's the takeaway. Even when the system removes parental rights, that doesn't mean a child's voice disappears. Children, especially older ones, have feelings, attachments, and relationships that must be honored. So to all listeners, if you're a parent, grandparent, or advocate fighting for a child's right to be heard, this decision gives you a weapon. Use it. The Canal County Circuit Court, where this case was originally heard, failed to uphold several key provisions of West Virginia law. West Virginia Code 494604C, that statute governs termination of parental rights. Courts are required to determine there's no reasonable likelihood of abuse or neglect can substantially be corrected. But the lower court didn't properly document those findings or evaluate post-termination visitation in that context. West Virginia Code 494601-2B. This law says a parent has a right to be considered for an improvement period if they can show a likelihood of full participation. That opportunity was denied here without the record showing why. West Virginia Rule Procedure of Child Abuse and Neglect Class Cases, Rule 15. This rule requires that termination visitation be explicitly addressed, especially when there's a bond between parent and child. The lower court completely ignored it. Supreme Court had to step in and remind them post-termination visitation is a child's right. Article 3, Section 10 of West Virginia Constitution, due process. Parents and children have constitutional rights to fair process. That includes the right to present evidence and have their interests weighed in open court. That didn't happen here. These aren't just technical violations. They're failures that impact the real families and the look at state's highest court to set it right. It took the state's highest court to set it right. This is why we do what we do. This is why Watchdogs Protection Services exists. We have another judge. That was Judge Akers. I'll show you her picture here. Judge Akers. We're moving on to another judge. Of course, these judges right here, they are in Canal County, West Virginia. Judge Salango. Let's not forget another figure whose actions call into question the integrity of West Virginia's judicial system, Judge Tara Salango. In September 2021, Judge Salengo and her husband, Kanawha County Commissioner Ben Salengo, hosted a graduation party of their teenage son. What began as a pizza party became an unsupervised gathering of over 150 minors. Underage drinking occurred, and two teenagers were injured badly enough that the law enforcement had to intervene. Despite confirmed injuries and violations of underage drinking laws, no charges were filed, no public finding of fault, no disciplinary, just silence. Why does this matter? Well, because Judge Salengo presides over family court cases where she enforces child protection law on parents, some of whom face allegations far less serious than hosting a binge drinking party for minors. In this incident reveals a troubling double standard, one for ordinary families and another for those in power. And in the eyes of justice, that hypocrisy cannot stand. We at Watchdogs Family Protective Services will continue to expose these families these failures, because when judges place children at risk and walk away without consequences, the whole system suffers. Judge Salengo also had a reversal. I'll read this reversal. It said, and if you needed more reasons to question Judge Tara Salengo's judgment on the bench, consider this. In 2023, the West Virginia Supreme Court overturned her dispositional order in case in RECL, a child abuse and neglect proceeding where Salengo terminated a father's parental rights to 4 children. The Supreme Court found multiple legal errors. Judge Salengo failed to properly adjudicate abuse and neglect for the 2 children. She did not adequately consider evidence, which we all know is a big problem around here, that the father had corrected these issues that led to the original findings. She ignored procedural rules under West Virginia Rules of Procedure of Child Abuse and Neglect. Most importantly, she violated the father's constitutional right to due process. The High Court vacated her ruling and sent the case back to for proper adjudication, stating clearly termination of parental rights demands strict adherence to law and procedure. This wasn't just a paperwork issue. It was a complete failure to follow the law in one of the most serious types of family court cases. When we talk about judicial accountability, this is why. The damage done to these cases isn't theoretical, it's real, and it affects families for life. Legal violations committed by Judge Tara Salengo. Judge Tara Salengo dispositional orders, which was overturned by the West Virginia Supreme Court in 2023, violated multiple laws, procedural rules, and the termination of a father's parental rights. West Virginia Code 494604C requirements. Parental rights can only be terminated when there is no reasonable likelihood that abuse or neglect can be substantially corrected. Violation. Judge Tara Salengo terminated rights without properly adjudicating conditions for the 2 of the 4 children and failed to consider evidence of the father's improvements. West Virginia Code 494601J requirements: an adjudicatory hearing must be held with specific findings per child before disposition. Judge Salengo issued blanket findings and failed to make child-specific determinations required by law. West Virginia Rule of Procedure of Child Abuse and Neglect, Rule 27 and Rule 36, Rule 27, requires written findings of fact and law to support termination. Rule 36 requires specific dispositional findings supported by record. Violation. Judge Salengo's order lacked specific findings and failed to meet minimum procedural standards. West Virginia Constitution, Article 3, Section 10, due process. Requirements: parents have a constitutional right to due process before losing custody of their children. Violation: Salengo denied the right by issuing an order without individualized adjudication or legal justification. The outcome: the West Virginia Supreme Court vacated her rulings and remanded the case, citing a failure to follow state law and constitutional standards for termination of parental rights. This source comes from Supreme Court of Appeals of West Virginia, 2023. There's a third judge we're talking about here, Judge Bailey. The failures don't stop with Judge Salengo in 2023. The West Virginia Supreme Court also reversed a ruling from Judge Bailey from Kanawha County. Judge Bailey had terminated a mother's parental rights based on her mental health history and past CPS involvement. But there's the truth. The Supreme Court found that Bailey shifted the burden of proof onto the parent, a clear violation of due process. The state, not the parent, has the burden of proof. A termination is necessary by clear and convincing evidence. Judge Bailey ignored this. Misapplied aggravated circumstances under West Virginia Code 494604C7C, using it to justify termination without proving that reunification was impossible, even though DHHR had offered and continued services. Bailey ruled as if they had not. Mental health was weaponized, no proof that the mother posed a continuing threat, no recognition of her treatment of improvements, no judicial speculation. Supreme Court vacated Bailey's ruling and sent the case back, stating that this decision violated state law and, once again, due process. And we ask again, if our highest courts keep reversing these judges, why are they still sitting on the bench? This is very hard of what Watchdogs Farm Protection Service is fighting for: real accountability and real justice. Judge Jennifer Bailey terminated parental rights was reversed by West Virginia Supreme Court in 2023 for violating state law, procedural rules, and constitutional rights. West Virginia Code 494604C, she failed to show clear and convincing evidence. That's a big thing here. They'd never do that. Clear and convincing evidence that conditions of abuse and neglect could not be corrected. She terminated her rights without fully considering the parent's progress or potential for reunification. West Virginia Code 494601, Bailey failed to conduct child-specific adjudications or enter individual findings for each child. The termination ruling was generalized conclusion. West Virginia Rules Procedure of Child Abuse and Neglect, Rules 2736. Her order lacked written, individualized findings of fact and law required for a valid dispositional ruling. West Virginia Constitution, Article 3, Section 10. Judge Bailey's failure to apply due process protections amounted to a constitutional violation. 14th Amendment to the U.S. Constitution, due process. She denied a parent their fundamental liberty, interest in the care of their children without adequate procedural safeguards. The outcome? This is great, the outcome. Thank God for our Supreme Court. The Supreme Court vacated her ruling, citing procedural failures, legal misapplication, and constitutional violations. There's a pattern of judicial conduct. Salengo, Bailey, Akers. The troubling reality in these judges, Tara Salengo, Jennifer, and Akers, they all share the pattern of systemic violations in family court. All three judges were reversed by West Virginia Supreme Court for issuing unconstitutional or unlawful termination orders. Each failed to conduct proper individualized findings before rulings, violating West Virginia Code 494601 and 494604. Each ignored clear standard and clear and convincing evidence and shifted the burden of proof onto the parents. Each denied parent due process protected by Article 3, Section 10 of the West Virginia Constitution and 14th Amendment of the U.S. Constitution. Each failed to document findings as required under Rule 27 and 36 of the West Virginia Rules of Procedure for Abuse and Neglect. And each operated in the courtroom that refused to recognize parents' fundamental liberty, interest in raising their own child. These are not isolated incidences. They are violations of law, ethics, and the Constitution, repeated by the very judges tasked with protecting the law. This is the Watchdogs Farm Protection Services, and we're raising alarm. Ladies and gentlemen, We're going to be talking about several different judges in the very near future throughout the country. We're just talking about three that are local to our county where we live in the state of West Virginia. This is systemic. There's no doubt about it. And, the biggest problem I have is, these are all public notifications I read, by the way, today. And we have plenty more. The problem I have is, they've been outed. But really, no punishment. They're still operating. They're still at Salango, Akers, all these judges, Bailey, they're all still in the big show. No fines, no reprimand, public or maybe even privately, I don't know. But the bottom line is without accountability, and that's what Senator Mike Stewart with SB Bill 944 was really trying to get across, that these judges need to be accountable for their actions. They are failing us as individuals. We are being destroyed by our judges. They are not following the rules, and they're getting away with it. Enough is enough. So this is a short podcast tonight. I'm starting something a little bit different. This is like a short reel. It's our first attempt at one. I'm going to go ahead and finish this tonight by saying, listen, we're trying really hard to correct this wrong, and it ends with the judges. They are the ending of our cases, but it starts with the CPS workers. We need CPS workers, we need guardian ad litem's, we need our attorneys, we need judges, prosecutors, police. We need every single individual involved in our family occurrences to be accountable for their actions. And even though I've read you 3 cases here, I'm telling you, I could probably be here for the next 6 weeks reading you cases throughout the country, probably for the next 2 weeks just here in West Virginia alone. So we're trying to out these people, letting them know that we're coming for them. We're not going to tolerate it. If you judges continue to violate our civil rights, we are going to out you. And eventually, we have federal lawsuits out there right now with three judges. In fact, I have one with Judge Salango, Abraham, and Bailey. It's an active federal lawsuit, all about due process. In one single case that I have, it's public. You can look it up. The bottom line is we have got to get these judges to the point where they understand that there are repercussions, and it's not just about a private little embarrassment of them doing this amongst themselves. We need to let them know that publicly. We need to let their constituents know what they're doing, what they really do when they go to work. Destroying families is not honorable. Destroying families is something that has to stop. I believe that these 3 judges and many, many more need to be penalized severely for their actions. And we're going to work on that. So that being said, we're not anti-family court. We are pro-justice. Thank you.